This is the December 3rd, 2013 meeting of the Raleigh Conservation Commission. This meeting of the Raleigh Conservation Commission is hereby called to order under authority of MGL Chapter 131, Section 40, the Town of Raleigh Wetlands Protection Bylaw, and the Stormwater Management and Erosion Control Bylaw. I will now call the roll for attendance. Dave Delmonico's presently absent. Bob Garner.
Here.
Judy Keys, absent. Sam Strife.
Here.
Kurt Turner.
Here.
Doug Watson.
Here.
Serving as chair, we have a quorum present.
We have a few minutes here, so I know there's a couple, you've circulated a couple of minutes,
Right.
and we have
Could
some
we possibly
administrators.
dispatch
Yep.
with just a quick bill type thing? This is a request for reimbursement for the monthly cell phone allowance and some ink cartridges that I purchased to make sure that I had more than one. And those are the backup receipts, if I could have your initial stuff.
Do you recall off the top of your head, Frank, whether we've approved the March 26th meeting, minutes of this year? I was late to a meeting and probably happened at that meeting. Or maybe I missed it. No?
I believe we did, because I've been trying to do from the first of year in order, or when I get a request, which is why I have two different minutes tonight. So I believe the answer to that is yes, but I don't have
Okay, very good.
specific record.
Dispatch of it in my usual manner. Which to my wife's chagrin means it sits on a shelf months before I get around to throwing it out.
Is everyone? Oh. While Kurt is signing that, Mr. Chairman and fellow commissioners, I've received a request from the Selectman's office for a capital needs assessment. And I must admit, I apparently didn't pay attention to the deadline on this. It was supposed to be put in yesterday, but of course this is the first meeting, and actually, I think I got it after the last meeting, but I'm not sure. Anyway, from Deborah Egan, Town Administrator, the Board of Selectmen has started the process of compiling a list of town-wide capital needs and requests for the next 5 years. Selectmen Bob Mary and David Peterson have been designated by the board to work on this project. We want to start this process now so that we'll have ample time to review each department's request before the next budget season begins. Attached is a department capital needs form. One bit yesterday, but I'll give it to him tomorrow. I probably won't be too far into the doghouse. On the capital needs form, they list equipment needs, examples, furniture, tools, office machines, computers. Then the next heading is facility needs, roof, windows, masonry, painting, building repairs, building expansion. Then the next category is vehicles, for those departments with vehicles. And you're supposed to provide a list. If you are a department that has vehicles, you're supposed to list the vehicles and then list your request.
Well, an SUV for you would be nice, but I don't think it's in the cards.
Motor scooter, maybe?
Bicycle.
Smart car with high clearance.
Right, okay, so no vehicles.
But seriously, I believe the only equipment needs would be the computers
Yeah.
that the office utilizes. They're cut off for capital expenditures. They usually figure $500 or more. That, looking around my office, that's the only thing I've got in the office that exceeds the $500. I'm assuming my desks and everything are, I don't know what they cost, but they should hold up because I don't abuse them. The desk chair is the only other thing that I've had to replace, and that's usually I can get it for under $150, so I don't think it is classified as capital needs. So therefore, with Commission's consensus, I would just note down the computers unless there's something I'm
Yeah, even those are barely $500. So, but yeah, I think that's right.
Yeah.
Can think of anything else?
Sure.
How about a drone to supplement your eye in the sky, swinging around people's backyards? It's a
Well,
coming
some of
thing.
those don't cost more than 500, so.
I think we as a town need to have a drone policy. Put some selectmen to work on that one.
Well, one of our august senators was mouthing off the other
The
day.
same opinion.
About, yes, about privacy. Well, there is no privacy anymore from, you know, the sky in the eye, and, you know, forget it. I mean,
No.
if he wanted to say something about safety, I would have respected that, but I don't respect his.
I'm not sure I agree with
Letting
you,
on about
not
privacy.
that it's on topic, but I think people still have an expectation of privacy from the second floor of their house, for example. And with a drone, there is none.
Well, you can go on almost any town in the country's website or city and look at their house in their webpage. And from all, you know, for tax assessment purposes. Never mind that, you know, we can get on Google Earth and what's on there anyway. But I think privacy is a lost thing,
Hopefully right.
as much as I bemoan the fact.
So we have minutes of Tuesday, April 16th, 2013. You circulated these, right?
Yes.
Yes.
Via
Yes.
email, yeah.
Yeah. Now, the copy you have in your hand, Jean Blanchard, our senior assistant, she and I went over and proofed this today and found a number of different grammatical errors and some instances where I'm constantly in the present tense and need to be in the past tense. So what you do have in your hand is a proofed copy that, to my knowledge, we didn't make any major substantive changes, but I apologize. She comes in this morning and I utilize her skill as the second set of eyes to catch things that I just.
You said you went to past tense, but, okay, yeah, that was
Yeah.
some of the things I noticed
Yeah,
earlier.
because I
Yeah.
constantly say, you know, that I reports and I say
Right,
and
right.
stuff like that when I'm supposed to say I
Try and be
stated, and I
consistent.
reported. Yeah.
I was willing to overlook that.
There was some confusion I had on page 3, and I see that you've altered the sentence. Under administrative, 1, 2, third item, new request for certificate of compliance, 630219,
Yes,
Aiken Basic explains
Yeah,
his
we
property.
rephrased
Previous
that.
owners, this is brothers.
the brothers, previous owners, that was their last name, Brother.
Oh, okay.
And it was
I thought
more,
there was
and it
something
was
missing.
more than one.
Okay.
There apparently were either brothers of the brothers, or a sister and brother, or something, sorry.
I thought there was some name of like a
No,
No,
facility or institution or something.
no, that's why she had me actually,
I mean, like the Jesuits or something like
Right.
that.
yeah, really.
Something like that.
The same question.
I didn't have anything.
That was really the only thing I noticed.
the kind of thing that I would have mentioned.
Anybody else have any alterations?
Nope.
In that case, is there a motion to approve the minutes as amended?
So moved.
I'll make that motion.
Second?
All in favor?
Aye.
Against? It's April 20, excuse me, April 16th,
Yeah.
2013.
Thank you.
right, so this is the 7:45 and 8 o'clock items on the agenda. The continued stormwater management permit for 111 Newburyport Turnpike and the continued notice of intent for 111 Newburyport Turnpike, both owned by Artistic Landscapes LLC. And I see Mr. Hurley is here. We have two memos from Brent. And I think what's happened since the last time we were here, my understanding is, this has been to the planning board. Planning board, I mean, there have been revisions to the plan in accordance with Mr. Graham's requests, sufficient to close the planning board hearing and approve the plan. Is that sum up about where we stand? Right. So then we have, in these two memos, we have a couple of what appear to be fairly minor adjustments requested. Two of them are from Mr. Graham, and two of them are from our own member Garner, or three of them. So Mr. Hurley, can I just ask, have the corrections requested by Mr. Graham been made to the plans, to your knowledge?
Yes, I have.
Yeah, okay. So these plans reflect those?
The plan
No.
should
Yeah, the one in front of us.
Yeah,
Okay.
just received, Mr. Holtz, also copied in what was distributed to you tonight.
Yep.
Was, a 3-page response of Mr. Holt to the planning
Oh, yeah,
board.
yeah, I should have mentioned that.
Yeah.
Okay. And with respect to Mr. Garner's comments, with 3 in number, you've seen this memo, right?
Yes, I have.
Okay, so the first one is a suggestion that the diameter of stone for the anti-tracking pad be somewhat larger. Is there any objection to that?
No objection.
Yeah.
We'll go,
We briefly discussed, but 3 to 5 inch stone would actually be ideal.
Okay, and that's fine with you?
that's correct.
That makes sense to you too, Brent?
Got my same recommendation.
Okay. And then the second point is a recycled concrete equivalent for the anti-tracking pad detail seems inappropriate. Is that also agreeable to you to eliminate that?
Agreed.
Okay. And then the third one is using plastic sheeting to collect the concrete washout. Your comments?
That we will have all the concrete washed out onto that liner, and then we'll pick it up from the liner using a piece of equipment.
Okay.
So,
So the purpose of the liner is just to control the liquid from seeping out.
correct.
Exactly.
Into
To
the ground.
contain it until it hardens, and then,
Yeah.
once it hardens, it'll be broken up
Right.
by a backhoe.
I was just concerned that it would be so much that it would be immovable at some point, that's all, and it would just tear or something like that. So it's a small amount, and you address the situation, soon.
Yes.
Then I guess it would be okay. But-
Reading the specs on the sheet, it says once it reaches 75% capacity, they're to let it harden, clean it out,
Right.
and then if they need
Okay,
to,
all right.
put another piece of plastic down.
So they've qualified a
Yeah.
little bit more. Okay, that's good, I'm fine with
Yeah.
that.
Yeah, they actually, I mean, and it's realistic how they propose to address it. And so we'll go through some more 10 mil plastic
Okay.
if they need to.
So anything else that you want to add, Brent? I know you just got these plans today, so.
No,
No?
I actually had the plans, I just,
You just got them.
I just got the memo, and I had been given an earlier communication, and I thought it had covered the points, but when I actually did the comparison point by point, I discovered that the email didn't have his responses to the stormwater appropriate items, and so those, I've reviewed the memo that came in tonight that was emailed to me just before the meeting, and
That being. Mr.
that's
Holt's.
appropriate, and,
Yeah, okay.
it's, be it as it may, it's not gonna change how things are currently designed or whatever, and it appears Mr. Holt's explanation about the orifice and where it goes, that is understandable in the context of it not fitting into his normal. And I believe Mr. Graham has seen this also, correct?
Yes.
Yeah. so-
Yes.
Anything
So
else?
therefore, under the stormwater management, we appear to have just in need of possible, just a couple pages revised for the stormwater pollution prevention plan. And the same thing if there were revisions to the drainage calculations that resulted from
No,
what he did.
no, there were,
Well, he did say that one of the catchment areas,
okay.
he did correct on there, so. Anyway, I'm just keeping it open-ended. I'm not looking for a whole new report, but if a couple of pages did change because of those revisions, we'd request that those be submitted. But anyway, I can recommend to the commission that we seem to have addressed what few items there were in regards to the issuance of the stormwater management permit. So Commission can give consideration to closing the hearing and issuing stormwater management permit with conditions typical for a commercial project within the Zone 2 area upon with receipt of the revised pages.
Right. So let's just talk about those conditions. It might be a good idea to do the four set out in Brent's memo.
Okay.
Those,
Those are,
that is a separate memo that is specifically addressing the potential order of conditions.
oh, yeah, okay, I'm sorry. I'm back.
Now, granted,
I get
these two permits are in a sense going to be synonymous, but I tried to keep all the stormwater, with the stormwater pollution prevention plan issues under the stormwater management permit discussion, just to allow us not
Sure.
to get too mixed up on it.
Okay, yeah, no, I'm sorry, I got a little confused there.
But then, since this is going to be a bylaw-only order of conditions,
Right.
and
'cause it's-
that's where we usually talk about any signage that we feel is needed to be protective of that particular resource area, which is the Zone 2. So that's why I'm just bringing that up, and Mr. Hurley, as his proposal, he's, and this is gonna be a landscaping facility, he's very much into some of these things, so I didn't want to just carte blanche throw down our boilerplate conditions. I wanted just a little bit of discussion about what made sense. We normally ask that there be some type of signage that identifies it as a public drinking water supply and prohibits the use of rock salt. We consider that both educational as well as on other facilities where they contract out their property maintenance. We also consider it to be an admonishment to the separate subcontractors who they may have doing their property management. So that's the reason just for discussing this. Very typically, it's a small sign that is white rectangular with a black border and black letters. It can be about the size of a sheet of paper or what typically we see sometimes for small no parking signs or
Okay.
whatever, that type of thing.
Yeah.
So, again, I spoke to Mr. Hurley earlier, and I know he's concerned about the aesthetics of
Yep.
his site.
Sure.
And so the commission obviously is concerned about protecting the resource area, so that's why I just didn't want to flop down the boilerplate
All right.
condition. so.
So, granting that this is relevant to the bylaw, not to the stormwater, are those conditions okay? Do we need,
Well, is
discuss any of them?
there going to be an opportunity on how you're laying out this site to have a display of at least one sign that says it's public drinking water sign?
I'm kind of wondering where they're going to go. Maybe that's the same question you're
Yeah,
asking.
I think so.
Yeah, I mean, I can make that happen. And I guess we can make that happen.
Okay.
Right now, I'm not sure where that's going to be,
And that's fine. We would only, I'm only suggesting that we would have a condition that when an as-built plan is generated of your site,
right,
that it does note where something like that is displayed, and that we have at least one instance of that.
okay.
If you, yeah, I mean, if you can't really figure out a place that you think, or that you're sure would be satisfactory, just call Brent
Right.
and confer. I'm just looking for where your snow storage area is. I've forgotten.
It's on a different sheet, it shows it here.
Yeah, there's numerous sheets, and I may not have
Right,
picked
right.
the right one.
No, that's okay. I just can't remember from the sheet that had it. So over here?
That's correct, that's
And wasn't some of it over
Yes.
in here too?
Was okay,
Yeah.
that's sort of what I remember too. Okay.
This
So
is-
certainly you could have signage for snow storage there that wouldn't be very visible to anybody.
Well, actually, I was gonna say, one of the things that I thought of recently and hadn't had an opportunity to have a site implement it yet, again, the first sites that we did this on, they utilized the same thing, a kind of an 8.5 by 11 size
Right.
white sign with black block lettering. But the other thing I thought of with the snow storage is that one could also utilize a 4x4 pressure-treated post and route in snow storage on it, and then just paint
Yeah,
the indentation.
Probably
So
lasts
that,
longer.
yeah.
as well as it wouldn't necessarily be so aesthetically
Yeah.
intrusive,
Okay.
done that way, but again, I know you're taking care of all this on your site, so like I said, we have both an educational component to it, but
There
also
is that.
in most properties, we're looking at another firm comes in to do this stuff, and so they kind of need to know where these areas are.
Okay. Brent, does the state use rock salt on their roads?
The short answer is yes. The bigger answer is that is in a state of flux, and you may have recently read the article about the pileup in Worcester, where they said that they had, Mass DOT had treated the highway ahead of time with a brine solution, so there are methodologies, and EPA is leading an initiative to educate highway departments and impose road maintenance strategies that use the least amount of salt solution as possible, both for protection of public water supply and also protection of the roads and the vehicles too, which that takes a toll on. So they are looking at mechanisms and strategies. Actually, our acting highway surveyor, Ron Keith, and I attended or participated on a webinar that went over some of the strategies and the mechanisms, looking to states. I think that one of the states that was a leader in this was like Minnesota or something, that was developing efforts to, again, minimize the distribution of rock salt on the highways and stuff for both cost-effective reasons, equipment durability, and also to lessen the contamination of their water supplies.
What I'm getting at is that if the state uses it, Lord knows when they'll get around to changing it, it might be useful to have at the edge of the road, at the beginning of his property, no salt area, and at the end of the property, at the end, no salt area. If the state's gonna come by with snow plows and spray salt all over his property, then it seems a little inconsistent with what we've been talking about here.
Well, except for the fact that early on in the review process, the areas that we had a fear were contributing roadway runoff to the property, that is being eliminated by the creation of berms or whatever, so that the roadway drainage is going to go down. You can never totally eliminate the spray and stuff business, but actually, Mr. Hurley's property should see a very minimal amount of contribution of items off of the roadway.
something he should be aware of in general, just because it may determine when he plants out along the edge of the roadway there, because you get salt kill in your plants and,
Because I would expect some salt. If they're driving 50 miles an hour down here, the salt is going to hit that first 20, 30, 40 feet because this is lower than the road.
Yeah.
So we will not be applying it, but
Right.
it may be applied.
Can only do so much.
So, any other concerns we need to discuss? Either of these?
The last one, number 4. In most cases, what the commission has normally done has required or specified the use of low nitrogen fertilizers, and then outright prohibited herbicides and pesticides being applied in the buffer zone to wetland resource areas. We don't have that same situation with your property, as well as I was expecting you to, say that you probably, hopefully, tried to utilize organic methodologies, and so I don't even know whether putting you under some kind of onus on the herbicide and pesticide category was even going to be appropriate.
I hadn't made it down to 4.
Okay.
When there was a sign outside, I'm like, well, we can make the sign work. Right now, if there's any treatments of a herbicide, I bring in somebody to do that. We don't do that ourselves. We're not licensed, and I have no particular interest in becoming licensed. The idea that we would not be able to store any fertilizers, herbicides, or pesticides concerns me in that 3 years ago, organics, anybody could apply. And now there's talk about needing a pesticide license to apply organics. So is the product that's being used today, is that going to be considered a pesticide next year? And now we're breaking our rules.
Actually, we don't address anything about storage. That's something you would have to deal with because you're in a municipal water supply district, which is not under our jurisdiction.
Okay.
This doesn't have anything to do with storage. This has to do with application on the property.
Okay. Yeah.
And so, yes, we have specified that any pesticide or herbicide treatments be organic based.
And,
But that's treatments, not storage.
Yeah, this is all dealing with treatment.
okay.
I mean, there's kind of limited areas in this property that's gonna be relevant. anyway.
Well, actually, it's all zone 2.
No, I mean, places where you would
But
find
yes.
cause to apply.
Yeah,
But it's not a large site, it doesn't have
I look
too
at
many
right now,
locations like that.
there is rampant poison ivy.
Ah.
And that's from the state, the highway.
Yeah.
So I can control what's on my property, but now when that comes in, I know what my goal would be to make some cuts and then spray it with Roundup or some other chemical product to stop the poison ivy from taking over again. So that's where I would be against having the restriction of being able to use it. I don't plan on using it every day, but I know there's instances where we'll want to use it.
Your thoughts? I'm all for stamping out poison ivy. Who isn't?
It's
it is a native species.
Yeah.
But yes.
So are mosquitoes.
Right.
Don't like them either.
So maybe we should just look at the restriction on fertilizers being low nitrogen
Interesting point.
and organic.
Where you're next to the highway like that, yeah. Most places I've ever looked at carefully next to Route 1 have poison ivy.
yeah.
It's just the nature of the
Yeah,
of
in
the beast there.
abundance.
Yeah. So I think you're probably right, you probably got it. That seems reasonable to me. What does everybody else think? Just a restriction to use of organic
to the use of organic fertilizer.
Low
Leave
nitrogen
the other part out, low nitrogen, yeah.
You gonna be selling container-grown plants?
Yes. And then I'll buy them from a nursery, and then I go to someone's house to install it.
Mm-hmm.
So,
Will you be fertilizing them
no.
on your property?
Ideally, we will buy them when we need them.
What I was gonna say is that I would object to putting that restriction on your ability to fertilize your container growns, even though there's probably holes in them. But, I mean, the nature of your business seems to me calls for a little leeway.
Well, again, this would only be for application to his
But on the ground.
surface
I'm not
area.
sure that would matter, yeah. I guess in theory, it could come out the holes in the bottom and get on the land, but I don't see that happening very often.
So-
I would think the way you would tend to want to run your business is you buy them as close to when you're installing them as possible, so you don't have the maintenance obligations and watering and all that.
Right. But maybe we do add that clause that if it's in a container, it's excluded. Because if it's in a container, it's going to be there, whatever, 2 months, 3 months.
Well, I'm gonna reverse that and suggest that we just specify applications to the property,
Itself,
To the property itself.
you know.
Okay.
since that's
Yep.
only because we're focused on the zone 2.
Right.
And that's the zone 2, not.
The plan. No, it's not time. Okay.
Okay.
And there was one comment about the highway department, and now that the driveways have moved 10 feet from the original plan, I resubmitted that into the Mass DOT, and they've approved
Oh, for your curb cuts.
the curb cuts.
You move it more southerly, was it?
Correct.
Yeah.
So they're still up, signed off on making the berm and closing everything else.
And then there was some signage adjustment that went along with that,
Correct.
yeah. Again, that's not directly going to affect us, but, yeah. All right, anything else that we need to talk about? Sounds like we're all
I don't
on the same
believe so.
page.
I think we've all.
So I need 2 different motions here. First one for the stormwater is to close the hearing and issue a stormwater management permit with conditions typical for a commercial project within Zone 2. Upon receipt of revised plans as appropriate, and I think we talked about what that might
Yeah.
be. So moved. Have a motion, is there a second?
I don't know. They got quite a meeting going in here.
All in favor?
Aye.
Aye. All against? So that's the stormwater. And the motion carries. And then I also need a motion to close the hearing on the bylaw application and issue a bylaw order of conditions with conditions typical for a commercial project within the Zone 2 area, conditional upon receipt of revised plans as appropriate, also as discussed,
The restrictions we discussed.
with the restrictions we discussed.
So moved.
And is there a second?
Second.
All in favor?
Aye.
Aye. And the motion carries. And I think you are done with us.
Thank you. Then do I come back to the January meeting for, no, okay. No.
No, get this down to me and I'll
You can
issue
if
the
you
permit.
Always, we like company.
We need another member.
Yeah.
Yeah, that's right. Can't beat them, join them.
Yeah.
When do you anticipate opening?
I don't think we'll be able to break ground until March or so.
Yeah, March.
Because
March,
we have
April.
21 days, I think, from tomorrow. From tomorrow will be our site plan.
Well, the planning board hasn't issued their permit yet, correct?
No,
They just closed the
They
hearing.
close the hearing, they're issuing that tomorrow.
Right.
So then it's 21 days, which puts us January 1st.
Not
So
to-
hopefully by June-ish,
Well, good luck.
and you can look that word up, June-ish.
Thanks.
Thanks.
Thank you. And thank Mr. Holt for his very professional work. He does nice plans, Mr. Holt.
Actually,
Very
Thad
meticulous.
Berry I think. Well, I'm not sure. They both worked on it.
But they're very meticulous, you know, they're very, if you ask them for more detail, you get more detail.
Okay, so.
David, hello.
Now, I'm sorry, I've got to mention this.
Okay. Mention.
I figured out how to go into DEP's order of conditions form, and I reworked it so that it's the Town of Broward Conservation Commission order of conditions form. Did not.
Hey, I didn't even notice, but you're right.
And I changed the page with all the different resource areas. I changed it all to match to the bylaw.
Really?
Resource areas.
Good work.
We only did one set of that, right?
Yes.
Yes, we've only done that, correct.
So you get that later.
All right. Now,
And Bob, whenever you want to give up your second copy, sure. You can leave them with me. Oh, tonight, oh, shit.
this is the 8:15 item. I have a letter received, received December 2nd, mailed November 27th, or dated November 27th, from John J. DeCoulis. Dear Mr. Baslak, we are currently working on our responses to the Horsley Witten report and need more time to complete our responses. Kindly continue the public hearing for the Marion Way project, file number 063625, to your January 7th, 2014 meeting. So this would have been the continued notice of intent for land off Daniels Road. Do I have a motion to continue that matter to the January 7th meeting?
So moved.
And is there a second?
Second.
All in favor?
Aye.
Aye. All against? And the matter is
Okay,
continued.
great.
Thank you.
Blow out on this folder.
Need number 3.
And then a capital item, duck pit.
Well, based on the Amazon story on 60 Minutes, which caused this whole hullabaloo, because that's where apparently they broke this strategy of having little drones deliver the packages. Maybe I could use the drone to deliver your meeting packets.
Tell you the possibilities. Or maybe you could just hire Amazon to do it. They seem to feel like they are up for it,
They're gonna own the skies.
like everything else.
For $100 a pop.
No, free shipping from Amazon.
Not on that.
No, probably
That's
not.
expedited delivery.
It's highly expedited delivery.
Yes.
If you can imagine it, you can have it. All right, well, that brings us to the 8:30 item, but it's not 8:30 yet, so you are
From 11 Clay Lane.
11 Clay Lane.
That would be the
okay.
next item on your agenda for 8:45. I got here a little early.
Yeah, that's fine. Well, why don't we talk about that? That's an administrative matter. So we'll do the 8:45 item, which is a new request for waiver of the ongoing condition number 24 for the pervious driveway at 11 Clay Lane, map 20, parcel 3, lot 47-1, Bruce A. Pacey Sr., and that is you, Mr. Pacey?
Yes,
Yeah.
that's correct.
Give me just a second here. I would like to give Mr. Casey the memo.
Okay, yeah.
I didn't
Be my first
have
question.
any,
You wanna give him-
no, I've got it right here. I just need to put my hand on it. Yes, I should have it here. Yeah, here it is.
is Clay Lane? Is that
It's off of Walden Farm Road. It's the little cul-de-sac off Walden Farm
Goes to the west,
Road. Goes
Yeah,
to the west,
north.
northwest.
whatever.
It's a left turn.
It's the only turn off Walden Farm Road.
Yeah.
So let's just, Mr. Pacey, take a minute and read that, and everyone else should read it too if they haven't yet.
Pardon?
The wetland is down here.
Is it in the buffer zone?
Well, let's see.
Yes, the driveway is in the buffer zone. The orange line is the outer edge of the buffer zone. The pink line is the no disturbance, the edge of the no disturbance zone. And the green line is the delineated bordering vegetated wetlands that's down the forested slope.
Right.
So I think you can see in the pictures.
It's quite a good slope there.
Actually, I think Mr. Delmonico has the picture I took specifically looking down towards the wetlands, where the other views are along, showing the condition of the edge of the maintained grass
Right.
to the forested buffer zone.
When did you pave the driveway?
Oh, 2 years after I moved in, I believe it was.
Be the first,
Yeah, I bought it from the developer.
Yeah, so we issued a certificate of compliance, I think, in November 1998, so that would have been around
I think we
99,
bought it,
2000.
yeah, we bought it in '98, moved in like right around Christmas time, actually. So it was frozen the first year, and then we lived with it that next summer, and I ended up paving it.
Unfortunately, you should have come in before us to get approval.
I didn't know that was an order of conditions, sir.
Put it on the deed, shouldn't it?
Well, this, you know,
Doesn't
this
go in
is,
the
this
deed.
is why the commission has adopted the policy of within our new permits, we require the submittal of an affidavit from when the property changes hands from the developer to the owner, so that there is disclosure of these restricted areas. I mean, I can't attest to, you know, what happened back then. Obviously, excuse me, I believe the closings are a little more detailed these days in identifying restrictions on the property, but there is, you wouldn't even know, because again, they didn't even require any type of monumentation for the no cut, no disturb out there, so you wouldn't even be intimately acquainted with the fact that you had a restricted area on the property, and you certainly wouldn't even know to ask about the driveway.
I mean, the problem is, and this is why we did the notification more recently than Mr. Pacey brought, is that there's every incentive for both the developer and the real estate agent to not disclose these things. Because it's only gonna make it less saleable. The more restrictions there are, the harder it is to sell, so they don't have an economic incentive to disclose it, which is not your fault. And,
In this particular situation, it's hard for me to tell now as to what the concern was, because in my site evaluation, I can't ascertain that there's been any type of deleterious effects. There's ample well-vegetated lawn transitioning into the forested buffer zone, and the forested buffer zone, I think at its minimum, is 20 to 16 feet, extending in some cases up to 40 to 50 feet in width before it actually hits the delineated edge of the bordering vegetated wetlands.
Like over here.
Yeah.
Well, it's probably the kind of thing that if you had known about it and come before us, we probably would have approved it,
Well, I think so. I mean, it's,
given the circumstances.
I think, it seems to me, I wasn't on the board at the time, but it seems that our thinking on pervious driveways has evolved a little over the years. It appears there was a sentiment that they were good or better, and now the sentiment is not so much that way because, you know, the gravel tends to be difficult to maintain and it gets washed down into the wetland, and that's not necessarily better.
Well, and usually, if I can interject here, usually today, we seem to also be much more aware of the stormwater considerations. So when we have driveways, we're perfectly acceptable to adapting the design so that it incorporates like crushed stone infiltration trenches if the driveway is concentrating runoff. In this situation where the driveway, in a sense, is parallel to the resource area and following basically substantially the same grade, or at least the down gradient is actually going towards the residence, which, when it gets to that point, is the maximum offset from the bordering vegetated wetlands. So here again, with the design considerations and stuff, I don't think the commission would have even thought twice about permitting it to be constructed originally with a paved driveway if it had been proposed that way.
Right. No. I'm also familiar with the property from driving by it because I live in the neighborhood, and it's certainly, yeah, I live over on the hillside, and it's certainly stable. It's as stable as it looks there. It's not the kind of thing that's changed in years, I would say. So I don't see the point of requiring this gentleman to tear up a driveway.
Well, that, again,
that
that has never entered, that has never entered into the
No,
discussion
no.
or whatever. The discussion was the
Yeah.
process for coming and seeking approval of the commission without even mentioning that as being an option.
But that would be the implication of not
Well,
permitting this, and I don't see the
Right.
value of that. I really don't, under the circumstances. I don't see the environmental desirability of it, put it that way.
Well, in fact, it'd be worse.
Probably, if anything. So procedurally, if that's the sentiment of the board, I guess what we're being asked to do is waive a requirement, condition 24, or is it 24 and 22? I guess it would have to be both.
24, just 24.
Just
No,
24.
no, we do not want to waive 22,
What is 20?
the no disturbance zone.
Oh, I see, okay, I'm sorry, I thought that they were both related. To waive
No.
condition 24 and issue a complete certificate of compliance with that waiver, is that procedurally where we're at? No?
No,
Where are we at?
we're way beyond the certificate of compliance.
Oh, that's right.
I was actually going to seek your counsel, Doug, in regards to this, because I think what the commission should possibly do is issue a letter that has appropriate information on it that would allow Mr. Pacey to record it at the registry so that it would refer to the book and page number that had the certificate of compliance that imposes those ongoing conditions.
Okay.
Otherwise, someone looking up, researching the property will find the order,
Yeah.
find the complete certificate of compliance that mentions those ongoing conditions. And if we don't produce a document that would allow Mr. Pacey to then go and record it,
Right.
they're, they wouldn't
It's
find it.
not linked.
Which is why he's here. The only thing about that, I think it has to be more than a letter, because it's gotta be something recordable.
Okay.
So it's gonna have to be, say, an order, something.
Maybe you and I should consult on this and just have the commission indicate by a motion their, desire and just charge us with accomplishing it.
Yeah, I'm trying to think. generally speaking, you can record almost anything that's notarized, so we could just do it like an order there's notarized signatures, just like our orders of conditions and so forth.
Well, again, actually, not everything even needs to be notarized.
No, not
You know,
everything,
we've,
but that's that's a sort of a general way to get something recorded is,
okay.
you know. Okay, yeah, let's you and I do that, if the commission is of
We're
a
fine with
sentiment to
that.
do that. So let's see, what I would want, I think, is a motion to waive the condition number 24 and direct the agent to prepare appropriate documentation for recording.
Right.
Sound right? Is there a motion to that? Any further discussion by anybody?
Only the acknowledgement that this might have to be something that we sign later on.
Yeah, I think we might. You don't have a buyer yet, do you? Not imminent? Okay. So we may not be able to sign this until January 7th, because we're gonna have to draw it up, and then
Oh,
we may
that's
need
fine.
everybody's signature
Do you need
on
me
it.
to come back
No.
on January 7th?
No, I don't think so. Assuming this motion passes, we don't
Okay.
need you to come back. We'll figure it out, and then we'll send it to you. But you need to either give it, your house is for sale?
It is.
Yeah, okay, either hang on to it and give it to the broker or the buyer's attorney when you have a buyer, or you need to get it recorded.
Okay.
And then keep a copy of it and give the copy
Okay.
to your realtor and.
Yeah,
Okay.
yeah. It's-
All right.
It's your job, not ours, to record it. So you
Yeah.
can either have your broker or your buyer's attorney do it, or,
Okay.
anyway, but we aren't gonna record it.
Not at the registry of deeds.
That's right.
That's fine.
That's your job.
Yep.
Okay.
Gotcha.
All right, so is there such a motion? Is there a motion along the lines I described? Dave, did you have a
So
comment? Okay. And a second?
Second.
And all in favor?
Aye.
Aye. All against? And the motion carries. So
Okay,
you
thank you.
should get something from us, if not in the next couple of weeks, shortly after January 7th, depending on how we switch that all.
That's fine, gentlemen, thank you.
Thank you. It's his wife calling to say, so how'd it go? Kidding.
Do you have to go buy a pickaxe and a sledgehammer, and which end do they make you start at?
I would just like to be on record as indicating that there may be times when we do want a driveway removed, and we should take each account,
Well,
circumstances on their
that's a
own,
good point.
even as
This
it's-
happens to be a very stable driveway with a very good
Right.
configuration to not ask for such a thing, but there could be other situations than that.
Well, right, which is exactly why I tried to present you with comprehensive site information, the photographs combined with the as-built plans, so that you could see what the exact situation was and
Yep.
evaluate it based on the site criteria, and not just the fact that it was done a long time ago.
And well done.
All right. That brings us back to the 8:30 item, which is the continued enforcement order of land off Main Street in Mud Creek. Daniel McHugh Jr., owned by Mass Audubon. I see Mr. Getty is here.
Yes, sir.
Anybody else here on that?
You're
Mr.
observing.
Rimmer from Greenbelt. is
Right.
here to observe.
No, I recognize you, I wasn't sure quite why, but nobody from the pending parties, but we have people here, so I think we should open the hearing. I've had a few more thoughts about this. We have had no further communication, I understand, Brent, from Mr. McHugh or his supposed legal representative. The first thought I had is, any remediation or anything here, I presume the owner of the property would not be willing to allow Mr. McHugh to perform it. You would not be willing to allow him onto your property to do that.
That is true. That is our preference.
Well, it's your right.
Yes, sir. We would
We
not want
couldn't,
him on the...
I don't think we could impose that obligation on you. So that, to my mind, raises the second question of whether any remediation is even necessary here. And I wonder what your thoughts are on that, Frank.
Well, actually, that was a point I would bring up. The nature and the specific focus of the removal of salt marsh vegetation, specifically salt marsh cordgrass, was directed at portions of the mosquito, what's commonly referred to as the mosquito ditching or the ditching of the marsh. And in the conversations with Mr. McHugh, it was expressed that he was maintaining the ditches, which is usually interpreted as being restoring the ability of tidal flow to make its way through those longitudinal trenches. But the manner of his impact and disturbance to the acreage in question was not consistent with what one would interpret as being a methodical way of opening up a ditch, because it was erratic, not had no continuity to the removal of the salt marsh cordgrass. It was done in not only different locations along some of the same extent of ditch, but then done on different branches, but never establishing a complete open condition of unrestricted flow through the ditches that the removal occurred or alterations occurred on. Again, whether this was the start of a more concentrated effort, and therefore it's unfair to view it in its uncompleted state, I don't know that, because Mr. McHugh and his counsel has not shown up this evening, although Mr. McHugh's counsel's letter specifically refers to coming to the meeting in 3 weeks.
Yeah, but even then, the problem is, we can't permit him or order him to enter on someone else's land to either finish the job or remediate.
Well, right,
damage.
I'm sorry, I should have finished, I'm sorry, I should have finished my kind of assessment. And therefore, because it was just sporadic removal of the cordgrass that fills in the ditch, it doesn't appear that that has provided any harm to the salt marsh plant community out there. It also has not restored unrestricted flow through there, which usually assists in the salt marsh plant community not being invaded by Phragmites or whatever when you get brackish, brackish water conditions where you don't get the circulation and the flushing of the tides. And so the long and the short of it is the actions which removed specific cordgrass plants or bunches of plants don't appear to have destabilized the portions of the salt marsh that they were on. They did open up what had been an historic ditch in terms of just establishing some width to it, but didn't provide, again, it didn't extend enough that it,
Right.
but there didn't seem to be any detriment, i.e. it doesn't appear that destabilized the surface of the salt marsh or the sides of the ditches, that it was solely directed to the batches of plants which, if left to their own devices, do appear to grow across and close off these ditches.
Could you refresh my memory as to how this came to your attention in the first place?
The police report.
The Raleigh police called me. They had received a call and dispatched an officer to the location because a resident or tenant of a house across the street saw people with 5-gallon buckets going down on the marsh, and he interpreted it as dumping.
Okay. Well, I don't know exactly where Doug is going with this, but seems to me that this is a matter between, at this point, between the parties in court or to come to some sort of legal understanding. I don't think that, as you've just explained, that there's no basis for any our continued jurisdiction over this or being involved in it. Mr. McHugh is a well-known expert in this sort of thing, has been before us on countless times on various matters over the years, and it's well established that he knows his salt marsh stuff, and whether he was doing it and whether he was doing it in accordance with his own deeds, which whether or not they have any value is up to Audubon and Greenbelt if and when he ever goes on their property. So I think we just need to bow out of this and leave it up to the parties.
That's really where I'm going with it. I think we have to satisfy ourselves that there's no remediation needed for environmental reasons, that the marsh is stable and that the best thing to do for the affected area is leave it alone. And then we can bow out gracefully and have done our duty. And I think that would be my instinct, and I think that's what you're saying, Brent, is that there isn't anything that would improve the situation there. The best thing to do is just leave it be and let nature take its course.
Right, I would point out, though, that there's still a violation exists. There's still an unpermitted alteration to regulated wetland resource areas. And even subject to the verbal pronouncements of the violator in question, Mr. McHugh, he has not demonstrated nor utilized the regulatory requirements to demonstrate to the commission that in fact he was engaged in an activity that may have possibly qualified for an exemption under the agricultural sections of the wetlands protection regulations. So at this point in time, I could only state that I don't believe the commission should, I don't know what the term would be, remove the issuance of the enforcement order or the declaration that there was a violation
That's not
under
what I'm
the
saying.
act, just only that it doesn't appear that any restoration
Exactly.
activities need to be directed by the commission in order to restore the impacted resource.
No, absolutely. I think my thought is we should confirm the enforcement order, which I think we've already done, but we certainly shouldn't retract it. The concern I came to this meeting with was how exactly would we approach any corrective action where the landowner is going to be strongly opposed to having the violator do it, and it would be unfortunate if the landowner was forced to do something to restore the property when they did nothing to damage it. And how do you get around that problem? And I think the answer to it is what we've just said. It doesn't need restoration. So, but that by no means, in my mind, means that Mr. McHugh didn't violate the applicable law. Quite the contrary, he's not here to convince us otherwise. So that based on that, my thoughts are simply, I think we've already affirmed the issuance of the order, or did we delay that until this meeting? I don't remember.
I believe confirmed it. I believe you confirmed it.
We normally would at the first meeting.
Yes, because I have all your signatures.
Yeah, all your signatures,
on it,
okay,
so-
that's right. So we don't need to take any action in that regard. I see no reason to retract that or reverse it. Based on your comments, and I assume this is satisfactory to the landowner, that we
I would-
require no
I did initially,
remediation.
since I wasn't sure of the nature of the extent of what had occurred, indicate that resource area alterations resulting from said activity shall be corrected and the resource areas returned to their original condition. So I would suggest if the commission wished to do anything is that you would solely amend the issued enforcement order removing that particular clause.
Okay, Mr. Geddes?
Yes, sir.
Any comments on all this?
Well, I'm just listening to this, and I think Brent did a very good job of detailing exactly the conditions out there. But my wonderment at this point is, what is, he did something wrong. He violated some laws and regulations. And what is, okay, tomorrow he does it again. I mean, what? I mean, what, other than not coming to a meeting and not showing at two out of the 3 meetings, what is to prevent him from just doing it again? And on my property, or on Essex County Greenbelt, or, I mean, why did we even do this?
In my view, I can't speak for the commission, obviously, he didn't necessarily do anything wrong. Is the question, as Brent pointed out, as to whether or not he falls within the agriculture exemption, if in fact it had been his own property. And my guess is that he would have fallen within that exemption, but since we aren't pursuing it, or I don't think we should pursue it, that doesn't come down to that. If it were up to me, I'd vote to remove the enforcement order altogether. But I'm comfortable leaving it in place and just forgetting about it or tabling it. But with the change that Brent just suggested, it strikes me as where it goes from here is between you and him, and we don't need to be involved in that. If he does it again, and he does it on someone else's property, and there's an issue as to whether or not he's doing more than what he was described as doing, which again probably does fall within the exemption of the Act, we'd have to take that case up when it comes before us. If it comes
Just for my clarification, what agricultural exemption was he working under? Because he didn't own the land, so
Salt
how
marsh
could he be
haying.
doing farming on land he doesn't own?
Well,
I mean, how is that possible?
my perspective is if he did own it, he would be okay.
Oh, but he doesn't.
I understand that, so that's a matter between you and him.
The problem is, we can't order him to remediate what he did, because we can't order him to do something on your land. This is why, when we initially addressed this, I felt, and I think the whole commission felt, that because he was not the landowner, his arguments were irrelevant. It doesn't matter if he has an agricultural exemption, because he doesn't own any land to have it on.
Right.
But that's pretty much where it ends for us. The dispute over, if there is a dispute over the ownership, that's between the two of you. It's not for us to decide.
Okay, so the act of going on and going out into a salt marsh and digging up plants in a protected area, that's...
On your own land, if you're a salt hay farmer. See, that's the
But
difference.
we already agree, you agree it isn't on his land.
Oh, I agree. Yeah.
Okay, so how is, I mean, I'm sorry, I'm having a really difficult disconnect here between, he did something that was not permitted on land he didn't own, for which he had no agricultural restriction, authorities at all.
But he
So,
did
but that's
something.
okay.
But he did something that, for the sake of argument, this is certainly not a finding by the board, but for the sake of argument, he did something that would have been permitted had it been on his own land. That's
Or-
strictly for the sake of argument.
May I simply add, or he had the authority to be on the land.
Yes.
Right. And his statement to us is that he believed that he did have the authority.
Yes.
Okay? From all parents that we have gotten, that's not correct. But we're not here to determine the legality of someone being on land, and that's really the question.
I'm going to interject. The Wetlands Protection Act and the Wetlands Protection Bylaw in the town of Raleigh solely regulate an activity that alters, dredges, fills, or removes a designated resource area. All of our permits have to have a clause in them specifically granting us permission to enter. The Act and the regulations do not give any authority to enter onto property. They only regulate the activity that may alter, dredge, fill, or remove. And so, in this particular instance, the violator has not availed themselves of the opportunity to present to the commission how they may possibly, their actions may have qualified for designation as an exempt. But that's for the commission to decide, not for the person performing the actions. And where they're not present, they can't avail themselves of the process that the commission would possibly prescribe to decide whether the actions possibly were allowed by sections of the regulations or not. But again, the fact that they were on a piece of real estate that it doesn't appear where they had any rights to be there isn't a violation of the Wetlands Protection Act, isn't a violation of the Town of Raleigh's Wetlands Protection Bylaw. That's solely a right to enter a property rights issue. I think if I'm straying out into portions of the law that I don't normally get involved in.
It's a problematic situation. I don't think we've ever seen it before, and I certainly hope we don't see it again, because not very many people would do that, would go onto someone else's land and do something like that. But it combines the needs of, or it combines the jurisdiction, I should say, of this board, which is very limited, with a basic question of law that only a court could decide. And we're pretty much limited to what we can decide, which is just that. See, the thing is, normally what we would order him to do, if we found he violated the law, was restore the property. That's clearly not available to us, because we can't order him to enter someone else's property. So we don't really have a remedy against him, other than to simply find him in violation.
Just a question, I'm trying to think of analogous situations that the board might have dealt with, like a neighbor accidentally cutting vegetation on an abutter's property that's in a wetland. A neighbor, or anyone accidentally dumping into a wetland on an abutter's property. Is that an issue that this board has addressed before? And I mean, it's kind of analogous to this, really. You've got someone that's come onto a property that they may have thought they had rights to, and they may have even thought they owned, but the fact of the matter is they didn't. And you know, altered a wetland.
I can't recall that we have. I think that one would
Well,
come up
actually,
often.
no, actually we have. Actually, the commission has dealt with that, specifically occurring on the commission's open space property, i.e. Yankee Pine Lumber.
Yeah, okay, on November 1.
And in those see, this instance is extremely unique. First off, he removed whole plants, root system, stalk, everything. But he didn't take them out of a stabilized native substrate. He took them out of the void, what had been the void of a ditch, an established mosquito control ditch, where they'd grown into that ditch and apparently utilized the accumulation of sediments flowing through the water to maintain their root systems. But when he took them out of that ditch, again, if you do it in a certain manner, it can be construed as being ditch maintenance, which is potentially, has the possibility, if approved by the commission, being an agriculturally exempt action. Totally different from depositing fill, totally different from severing the upper part of a woody stem plant from its root system and taking the top portion off-site.
See, the situation in Yankee Pine, if I recall correctly, was there was fill that was dumped over the property line onto what happened to be conservation land, so it belonged to the town. And they inadvertently, in effect, expanded their parking lot several feet farther than they should have. So we, as the owner of the land, both required and permitted them to enter our land to correct the condition.
Right.
But that's really a lot different than this. And I can't think of a situation that's analogous to this one.
But that's why I started with the question I started with, which was, even if the landowner decided to allow Mr. McHugh onto its land in order to restore it, would that be an appropriate environmental response? And I think the answer is probably no. That replanting or further alteration of that situation, that condition, would not be an improvement. That the thing we would probably order somebody to do is do nothing, because that's the best thing to do. So that's also unusual. It's unlike a fill situation where we were able to order Yankee Pine to remove the fill. Simple enough. They went in, they removed it, restored the plants to their proper condition. Sometimes we order people to replant, but does that make sense here? Probably not. But again, in this situation, we couldn't order Mr. McHugh to do that. We can't order him to go on your land. Even if we were so inclined, we couldn't.
And exempted activities do not require any notification to the commission prior to their commencement?
Well, in this particular instance, I sought the advice of DEP Northeast Regional Office wetlands personnel, who I also happen to know has a background in agricultural activities on the North Shore. And his advice was that the violators should have been informed that they should have sought and informed the commission of their potential activities and what and how those activities did explain those activities so the commission could make a decision if in fact they did qualify to be exempted activity. Because the tricky thing here, and is where most people, well, excuse me, I'm going to speculate, but in my 20 years experience of being a conservation commissioner in another community, I can tell you that the major thing that gets people in trouble with violations is when they self-diagnose themselves as being deserving of some particular reading of the regulations, when in fact it's the local permitting authority that needs to make the interpretation of the regulations and either confirm how they're proposing to do it or not. It does happen to lots of times center itself on agricultural activities, but that's mainly due to the fact that there's a substantial portion of the regulations that
And certainly,
talk about agricultural activities, as well as that's a pretty commonplace activity here on the North Shore where we haven't totally.
I know we don't want to beat this thing to death. My last comment will be, there's obviously a fair amount of agriculture that goes on in Rowley, I'm aware of. How does the commission react with some of those farmers? There's even salt marsh haying that occurs in other areas, and I'm sure as part of that, there's cleaning of ditches, there's little bridges that get built across the ditches so the tractors can cross. There's activities that I would imagine those folks might not be coming to the commission before each time they do it.
Well, in general, we try to keep those lines of communication
Yeah.
open. That's our goal, and I think, Brent, you in particular have done a really good job of making sure the farmers in our town talk to us.
Yeah.
When they have a question, they know they'll be listened to, and they know that we'll work with them. And that's the way it seems to work best.
Right.
Most of my interactions with various people, including some folks that are still doing salt marsh haying, is usually the fact that there are no interactions because they have a soft, light touch on the land, and they engage in their activities, and their activities don't result in the broadcast of sediment down water channels or the huge clouds causing turbidity drifting by the marina or someone's residence that then result in a phone call. So
They
Most
kind
of
of know
them
the
are-
rules.
Well, most of them are
From
also
talking.
pretty respectful and
Yeah.
understand that that type of degradation usually detrimentally impacts their ability to raise a crop or to harvest a crop or whatever, so I know of a number, and yes, the commission has had some cases, one specifically I can remember, where I did request that the farmer come and appear before the commission, because what they were doing on a crossing really needed to have a determination by the commission as to whether it was depositing material in a floodplain that was detrimentally taking away flood storage capacity, or whether it was just what was necessary and so minuscule that it was only stabilizing the crossing that they were using.
Would it be asking too much for the enforcement order to include language to suggest that Mr. McHugh come before the commission before he does any further, removal of vegetation or other activities that he may determine to be exempted, but may or may not be, whether anywhere in the town of Raleigh, whether it's on land he owns or land he thinks he has agreements on, or is that asking too much?
I don't know that I'd be willing to go there.
Maybe inherent in
I mean, yeah, we're really just restating what the law is there, and that just, I mean, what he primarily did wrong was he did it on land he didn't own. Other than that, the activity wasn't egregious. And I'm not sure I would single him out, as Kurt was saying, I'm not sure I would want to single him out for that. Had he done it on his own land, it would be a far different situation. So.
Could I just ask you, with this enforcement order, what does that do? I have to tell headquarters is, so the end result of this is, he went out there, he shouldn't have done that, but because it's on our property, we have an enforcement order, but what does the enforcement order do? Apparently, he could go back there and do plants tomorrow and,
Not on your land.
well.
But that's a civil remedy you would have. I would tell your headquarters that if he does it on your land again, you need to get civil or criminal remedies, or both. It's trespassing, and trespass is both a civil and a criminal violation, and he's clearly violating both of them.
Okay, but the enforcement order, what does it tell him that he can or can't do?
It tells him he was wrong to enter your land and do that activity. That's what it says. As I see it, that's all we can say.
And if he did it again, the board would find the same finding?
I can't say that, but yes, I don't know that we have any choice. In the odd situation of somebody engaging in an arguably permitted activity upon land that is not arguably even theirs. Probably if we ever see it again, it would be him, but I don't think we'll ever see it again.
I don't bet often, but I bet against you.
You could be right about that. Any other comments by commissioners? Anything else either of you gentlemen would like to add?
No, sir, thank you very much for your...
Thank you. So we just need to, I think we need to amend and affirm the enforcement order in the respect.
Just remove the requirement for restoration.
Remove the requirement for restoration. Is there a motion to do that?
So moved.
In a second?
Second.
All in favor?
Aye.
Aye. All against? Thank you. Thanks for coming out.
Okay.
I got it, thank you very much. Gentlemen, good evening.
Appreciate your
Thank you very
continued
much.
presence. Didn't expect that.
I can't.
What else you do? would have been interesting had the proponent of the position showed up.
But the determination would have been no different. Unless they came out with proof that they owned it.
Well, proof that they have the right to do that.
Yeah.
It's not proof
But
of
the
ownership.
argument would have been,
I don't think.
you guys regulate activities, not ownership. We don't want an enforcement order against us for something we were allowed to do, regardless of the question of ownership to one side. I could see that point.
Yeah.
So it's kind of the point you made.
Mm.
But they weren't here to argue it. And I'm not sure that would have been our decision either, frankly. The main problem I would have with that, this is totally hypothetical, but is that the activities that were observed did not look, in some respects, like ditch maintenance.
Well, exactly, that's why I said what I said.
That's
It didn't,
that's an after-the-fact.
it didn't restore the continuity of flow.
It didn't, and it was, the plants were taken
Well, as
in
I'm
their
saying.
hole and put into pots.
And
so-
statements were made both to the police officer and
Right.
to myself that they were being thrown on a compost bin,
Right.
and yet everything we saw and viewed didn't support that particular statement.
So I'm not sure we would have reached that conclusion. So. All right, next item on the agenda is a 9 o'clock request for certificate of compliance, 162 Leslie Road, map 7, parcel 20, lot 1, Kenneth Murphy. I think there's a memo on this.
Yes, there is.
Owner unknown.
Yeah, that's it.
So you did go out, right, Brent?
Yes.
And found some remaining silt sock?
Yes. Well, they actually hadn't asked me to evaluate its removal around the restoration area.
Yep.
They had asked for permission to remove it off of the driveway corridor and stuff that had been seeded with grass, and that had become firmly established. And so let me just bring my memo a little bit here. So we issued a partial certificate of compliance. I think that was in June, I think. And I guess after that, sold the property, but neglected to notify us with who the new owners were or contact information for them. So that's an outstanding point at this particular time. In regards to the restoration area, this was where a very small dumping site had been encountered, and, which, again, the size of it is probably 2 of these tabletops, and then a smaller subsequent portion that's probably equivalent to about 2 of those chairs actually extended into the bordering vegetated wetlands. So there was mostly restoration and replanting of buffer zone, but also a small bit of bordering vegetated wetlands. We've received 3 monitoring, well, if you count the establishment report. The area was established and planted in November, which corresponds with plant dormancy, so the plants were put in dormant. They did survive 1 overwintering period, and I had advised the applicant to wait to make this request for a complete certificate, so we could see how things went through this full growing season. The conditions call for 2 growing seasons, but that's predicated on an assumption that you might not get the 75% reestablishment of the plant community that the regulations call for. And in this instance, we've probably got 100% reestablishment.
Yeah.
Well, most of it's buffer zone, which actually isn't subject to that regulation, but because we treat the buffer zone as a resource area, that was also made a requirement for the restoration of the buffer zone, that it be 75% established with the plant community.
Yep.
And that has definitely happened. There's actually 100% coverage. As you
So
can see.
my concern is, receipt of ownership information, that's well and good, but it doesn't sound like we're going to get that affidavit we were just talking about.
Well, but this order of conditions didn't require that, because this is an old order of conditions that got that got further extended by the Permit Extension Act, the last portion. So this is actually an order, I think, that was issued, was it 2006? No, 2007. And we hadn't modified our conditions,
In that, back then. Okay.
you know.
Can I interrupt and ask where 162 Leslie Road is? It's not all the way at the end.
No, it
That
was
was
the,
more
it
recent
was the further north, but still bordering the mink farm. This was a 2-lot
Yeah.
subdivision with both driveways cross what had been kind of a ponded area that mostly may possibly function as a vernal pool, but we didn't, we weren't able to come up with any data to actually support that. But it did, because the old historic culverts under the driveway were both undersized as well as not maintained and were clogged, both areas ponded in front of the house.
This used to be on
This is the
Private
buds.
Buds.
Yes,
Okay.
this is the buds, or part of the buds.
Yeah, yeah.
Not the actual portion that had the mink cages and sheds and stuff, but we had the barrels that had the fish scurry in them.
So these are the new properties?
Yes.
Yeah, right nearby, okay.
Yeah.
Okay, so that addresses the lack of an affidavit.
Right.
Certainly, we need receipt of ownership information, but I assume Mr. Murphy's going to be able to deal with that.
Yes, I spoke to him to make sure, because I had a suspicion that, because he's working on, I'm not sure how this happened, but Mike Kovalchuk had started the development on 156, but then stopped, and now Mr. Murphy has taken that over, so Mr. Murphy's actually building the second house on 156 Leslie Road right now. This is the first house Mr. Murphy built, because he was the original developer buying 162, and that is completed now. And it appears that everything is, is all up to snuff. The wetlands area looks fine, the posts are all in place, the signage, the fence. Just has to get the erosion control out of there and really give us the names of the new owners as he was supposed to. And so that's why I make the recommendation that it be contingent upon receipt of the ownership
Yep.
information and verification that the erosion controls have been removed in that day. So.
Any other comments by commissioners? In that case, do I have a motion to issue a complete certificate of compliance with the listed ongoing conditions contingent upon receipt of ownership information and removal of erosion controls?
So move.
The second?
Second.
All in favor?
Aye.
I
Aye. Against? And the motion carries.
Those that one. I can almost remember the hearings on it.
What's that?
I can almost remember the hearings on that.
On what?
The property.
162?
Yeah.
How long
I
ago
shouldn't
was it?
say almost.
Yeah, these are,
Because that's.
and these are the ones where we had the unfortunate circumstance where Marty Howard, I think, Tom, is that the correct name? Who was the partner with Tom Mineta, who
Yes.
passed away
Mhm.
of of a heart attack or something, obviously unexpectedly, and we're in the midst of doing some of these projects. But we had the unique culvert design where there's 3 culverts that actually go through the driveway, and they're positioned as such that the smaller ones at a lower inlet elevation, and then there's 2 larger ones that are a slightly higher elevation to take care of the 100-year storm events, but to sustain the regular, normal flow during regular seasonal time of years, to still allow the seasonal inundation in case those areas do function as vernal pools on there, so.
All right.
We're on schedule.
Pretty good, huh? Always helps to have one continuance in there.
Please set it.
You all set, Fred?
Yeah.
So this is the looks like 9:15, close enough. The 9:15 item on the agenda, continued offer of acquisition of a conservation restriction by Mass Division of Fisheries and Wildlife on Brad Street Farm open space, map 26, parcel 26, lot 1. And I see Ann Gagnon is here from Mass Division of Fisheries and Wildlife. Welcome, Ann.
Good evening.
Good evening. So, let's see. When you were last here, we had a rather limited contingent of commissioners. I can't remember who was and wasn't. Sam, you weren't here? Or were you
Correct.
here? You were not here at the last meeting?
I was
No.
not at the
Addressed
last
this,
one.
yeah, okay. Yeah.
And I don't,
Dave, you weren't here.
I don't know if Mr. DeMonica.
We were, okay.
Oh,
You were?
No, I don't.
No, you weren't.
No,
okay.
No, I believe
there
he
was
was
another
sick.
woman.
Yeah.
Judy. Right.
Yeah,
Yeah.
and then Judy's out today. So, further comments by any commissioners? Further thoughts in the last 3 weeks?
I guess, I think it would be helpful, in my mind anyway, to sort of retrace what has happened here. And what has happened is that this commission, when the matter first came up, believed that it would be appropriate and justifiable to approach the Community Preservation Act Committee to petition that body to approve a grant of $18,000 for doing the conservation restriction and the associated things that they indicated would attach to that in terms of ongoing review and maintenance and protecting the conservation restriction on an annual basis. The timeline of all that happened in such a way that Ms. Gagnon was present either at the first meeting or the second meeting on this, and indicated that the Mass Division of Fisheries and Wildlife could also do a conservation restriction on that. The fall town meeting came upon us very soon thereafter, and it was the sense of this body, I think, as well as the Community Preservation Act Committee in which I sit, that it would be useful and appropriate to proceed to get the matter on the agenda, assuming that the Community Preservation Act Committee approved the spending of the $18,000 and that the selectmen approved it. And in fact, that occurred and the town meeting took place, and a firm offer came in subsequent to that from Mass Division of Fisheries and Wildlife, offering to do it for free. And we are faced with the fact that it is an accomplished matter and it's gone before town meeting and has been approved, $18,000. Question remains as to what our continuing role here is. The way I see it is the only role we have in regard to this matter is to work with whomever winds up with the conservation restriction of working with them to make sure that that process goes smoothly and is worded appropriately. And the way things stands, that would mean the Audubon Society, Mass Audubon. I personally don't feel that any purpose would be served by trying to redo that. The matter from a financial standpoint is probably precarious from your standpoint because it's been approved by the town and it's already incorporated within the accounting structure of the town that this is money that can be forwarded to Audubon, I assume, when they ask for it. I don't know that may already have happened. I don't know whether it has happened or not. Since I've heard nothing to the effect that it has, I haven't inquired on that. Whether it's too late to change horses once the carriage is way down the road, I just don't know. And I'm not sure that it's our role to do it. It seems to me that since our only involvement is to assist with the conservation restriction at this point, that we are not in a driver's position here. It seems to me it's up to the selectmen as to whether they wish to change their minds, and it seems to me the process would be at that point, if they did wish to change their minds, would be at the next town meeting, well, first of all, put a hold on the finances, and secondly, so that it doesn't get spent and approved. The spending of it has to be approved by the Community Preservation Act members. Have to sign off in every single bill that comes in. That's all I mean by that. But presumably, if the selectmen wanted that to happen and put a hold on it in time, that they could then go to the next town meeting and ask to move the money away from the account of the Community Preservation Committee, where it is now, pegged, identified and tagged for use by Audubon, and to put that money back to the Conservation Commission, and then make a determination to go with the no cost role, and maybe it would be might want to refer that back to us again. But my sense is they're also looking for some final determination by us, but my view personally is that we've made a final determination. Anyway, you're welcome other people's thoughts.
Go ahead.
I'm not sure in everything you said, Kurt, I understand what you're saying, but when I look at this from an outside, I'm not sure outside is proper, but from an outside view, number one, assuming there is no written contract regarding dealing with Audubon, until we either pay a bill, which would have had to go through CPC and hasn't, I believe.
I've not been notified that it has.
Right? Or if there was some written agreement, well, that's the contract. My point is that I don't think it's been finalized to the point that it's legally irreversible.
I agree.
Okay. Consequently, I basically agree with you that this isn't our bailiwick. The only possible thing we might do is express some preference, and I'm not sure I know I'm not ready to express a preference, not having heard further about it. That's it.
The sense I get informally from the Board of Selectmen's office is that they feel that if a decision to make a change is needed, it should be a joint decision of the Board of Selectmen and the Conservation Commission. The suggestion was made to me that we could consider, for example, a joint meeting to address it. I think my sense is that both boards are trying to be respectful of the other's jurisdiction here. Certainly, my feeling is that the question of finance of town monies is solely for the Board of Selectmen. It's really beyond our scope. Their feeling, as I sense it, and this is certainly not a position they've formally taken, is that the matter of which conservation restriction holder would be better from a conservation point of view is not theirs to decide, it's ours. So we kind of have a situation where both boards are trying to be cooperative, and neither one wants to make a decision that's final. Just the same, the decision that stands at the moment is I guess my sense would be, unless the two boards act jointly to reverse it, I don't see that I would be comfortable reversing it without the Board of Selectmen's assent. So Anne, so you've heard from 3 members. Your thoughts?
First, I wanted to make sure that you all had a chance to read my last email that I sent to the town administrator.
That was,
For the record.
that was distributed to all the commissioners, they have it in front of them.
Okay. I don't know if you had a chance to read it, so I made sure I brought extra copies for everybody, just in case. So it was my understanding,
I haven't read this.
yeah, I think you just received it tonight, so, it's my understanding that, the town administrator sent an email, to, let's see, I guess, she sent it to me and the selectmen, and CC'd the Conservation Commission and Town Council on Tuesday, November 19th. And you, I think Brent sent that to all of the commission members. I'm not sure when, but certainly before tonight's meeting. The very next day I replied to that email, the 20th, in great detail, kind of outlining what had happened, and you do have that before you this evening. So basically, to bring everyone up to speed, in case you hadn't been here the night that I was here earlier, it's my understanding that in the end of August, Brent at one of your Conservation Commission meetings suggested that you really needed to get this conservation restriction done on the Brad Street parcel to bring the town in compliance with the CPA, so that you could possibly apply for a land grant for a Girl Scout property that may or may not be up for sale. I happened to be in attendance fortuitously regarding a salt marsh parcel in this grant application that Fish and Wildlife is applying for. And so when Brent and I attended the subsequent selectmen's meeting to talk about that salt marsh parcel, I approached Brent in the parking lot that same evening and said, gee, this would be a perfect fit for Fish and Wildlife. We could accept the CR for free because we're applying for this NACA grant. And gee, the town could save $18,000. Do you think that there would be any reason why the commission would not entertain that? Is that something that we could we could work on. And at that time, Brent said, yeah, that makes complete sense. Save the money, and yeah, we could pursue that. So subsequent to that, I have many emails back and forth with Brent about the details of that conservation restriction. Now, shame on me for not immediately after that conversation, that selectmen's meeting conversation, shame on me for not sending a letter in writing to the commission and the selectmen as a whole, very formally, saying, gee, you know, Fish and Wildlife could do this for nothing. We have some things we have to check on, but we could make that happen not only at no cost to the town, but relatively quickly, because if a conservation restriction is granted to a state agency like Fish and Wildlife, it doesn't have to go through Irene Del Bono, Division of Conservation Services. So I thought it was a win-win situation. Because I was in close contact with Brent, I assumed that the commission was all also up to speed on all of our emails, and so at any rate, it was my understanding that you were that the commission was going to continue to submit this article at town meeting to put aside the CPC funds. Now, I wanted to clarify, is that $18,000, would that be coming from the Community Preservation Act funds? Okay, it's not from conservation funds, okay. So it's my understanding that that the commission was going to continue, and the selectmen were going to continue that approach, and I advised Brent that if I was a conservation agent, I would do the same thing, just in case Fish and Wildlife didn't, you know, the commission couldn't come to exact terms with Fish and Wildlife. If for some reason, you know, it wasn't approved at the state level, it wouldn't hold you up. You wouldn't have missed your town meeting cycle to go ahead and acquire funds for, you know, another entity to hold the conservation restriction. So I was, quite frankly, very surprised when Brent said, "Oh, you don't have to come to the commission meeting to discuss the CR. You know, the commission has decided to give it to pay Mass Audubon to take the CR." So I subsequently, at that same when Brent sent me the email that said, "Oh, you don't have to bother to attend the Conservation Commission meeting," he also asked for information on our specifications for baseline documentation reports. I brought a copy back with me. I had lent Brent one earlier. I don't know if all the commission members had a chance to review it, but I also gave him our specifications, so an example in our specifications which show that our reports are very substantive, etc. So I thought maybe that was one of the reasons why the commission had considered, gee, maybe it's worth it to pay Mass Audubon to accept this CR, because maybe you weren't familiar with the fact that Fish and Wildlife does this on a regular basis, that we do have very stringent specifications for our baseline documentation reports, etc. So I just don't understand why the town would want to spend funds that they could allocate towards another CPA project if they didn't have to.
Brent, would you like to comment?
No.
I was gonna say, you can say.
My perspective on that is that the timeframes just.
Well, as I
We're
said, it
we're
was
short.
about the same time.
Well-
I mean, it was literally the same. I attended the first meeting that this was discussed at. That's the selectmen's. The very next selectmen's meeting is when I brought it up to Brent. And at no time did anyone say, "Oh, stop work on this." You know, I've already drafted the CR. It's ready to go. I mean, if you're concerned about, you know, applying for a land grant, It seems like this would be a perfect opportunity to get the job done quickly and in a financially, appropriate manner. So I would strongly urge the commission, and the selectmen for that matter, to have a joint meeting and, if there is a real, if there's a good reason that I'm missing as to why the funds should be expended, I'd feel free to educate me.
I am going to make a comment now based on some things that were said. The commission has always been made aware of any discussions I have. I have also always made it a habit to make myself available for preliminary review of materials, or as DEP refers to it, pre-permitting conferences, but have never and always tell anyone I'm discussing with that I am not the deciding, I am not the person who issues decisions. All decisions are made by the commission. I am not a commissioner, I am the conservation agent. I always make myself available for people submitting items preliminarily. But in the case of drafts of conservation restrictions or other documents like that, the Conservation Commission's process in the town of Raleigh is to always review those documents through the full commission, with every commissioner having a copy. And that this, in the discussions with Ann and the process with Ann, had not gone to a point where Ann had made a formal request either to the commission or to the Board of Selectmen for the town considering Fish and Wildlife as the holder of the CR. B, the discussion after the Selectmen's meeting where it was first broached that this could possibly be a consideration of Fish and Game holding the CR, it was stated to me that the land committee that you apparently answer to needed to issue some kind of approval to you. I don't know what that process was or whatever, but that approval had not been given to you after the Selectmen's meeting that occurred shortly after the August 20th meeting of the Raleigh Conservation Commission. And also when we had the conversation after the Selectmen's meeting where you broached the topic of an actual possibility of the option of Fish and Game holding the CR, I disclosed the point that we were at and the fact that I had been directed by the commission at the meeting of August 20th after you left to specifically work on applying for the CPC funding for the purpose of providing an endowment to Mass Audubon to hold the CR. So that, I'm going to leave it at that.
I have a question, Chair.
Sure.
So when I submitted the draft conservation restriction to you, Brent, did the commission, has the commission reviewed it? Have you?
Oh,
So,
you had not formally asked the commission to consider granting of a CR. I believe that finally occurred, and this is the continuance of that request from our last meeting of November 12th. And no, the commission has not been provided with that document because that was considered, as I just stated, as just preliminary permitting discussions.
so typically, I guess I was confused because I myself worked as a conservation agent for 15 years, something like that, many years, for 2 or 3 different communities. And I always, in each one of those communities, the commission members would get copies of all correspondence. It wasn't, so I just assumed that that was always the case, that all
Probably before the open
correspondence
meeting
is,
law.
all correspondence is public record, and so I just assumed that the commission would have received, you know, all the emails that I had been going back and forth with Brent with, and absolutely the draft CR, et cetera. So this is the first time that I've run into a situation like this where, you know, because there wasn't an official letter to the commission itself.
Well, I don't think that's exactly what happened here. Is I reconstructed it, I wasn't at the crucial meeting, the August 20th meeting, so I only rely on other people's reports about that, was that the, at that meeting, the decision was made to move forward on the Mass Audubon plan. And it needed to be made at that meeting because the warrant for the town meeting was closing very shortly. And the warrant needed to be drafted, warrant article needed to be drafted. So we, the commission, was, we're in a position, we were told by the selectman's office that we needed to move that matter forward if we wanted it on town meeting. And that decision was reached at August 20th meeting. Now, since I wasn't at the meeting, I can't say this of personal experience, but what I perceive happened from that point on is that both this board and Brent and the Board of Selectmen and eventually the town meeting did not see that at all as a backup plan, that was the primary plan.
Mm-hmm.
And that you appeared, and your proposal appeared after that
Mm-hmm.
as a potentially viable plan.
Mm-hmm.
So from the selectmen's point of view, that's what we gave them and that's what town meeting approved.
Mm-hmm.
I'm not, I don't sense that the selectmen think it is legally not possible to reverse that, but they distinctly see that as a reversal of a decision.
Mm-hmm.
And being as it is in part a fiscal decision, I think that's for them to decide whether that's a decision they want to make or not.
Mm-hmm.
It's not, I'm not, speaking for myself, I'm not comfortable reversing our decision without their concurrence. I don't think it's for us to do that, and I don't think it's for us to make that decision by ourselves. And I don't sense that the selectmen expect us to. I also don't sense that the selectmen particularly, well, no, I'll stop there. I don't know what the selectmen sense, because this is not something I've discussed with them. It would have to be discussed in some kind of an open meeting. We haven't had that meeting. So it might be helpful to have that, but I don't feel that I'm prepared to reverse the decision to use Audubon for this at this meeting.
I have a question. So I have actually two questions. One is, do you see any reason why it would behoove the town to spend the money on that particular project? I understand, if there's, I guess what I'm getting at is, you mentioned earlier, Mr. Chair, that you thought that the selectmen, it's the selectmen's purview or to look at the fiscal issues and to make the fiscal decision regarding a CR matter, and that the selectmen would look to the Conservation Commission, and rightly so, I think, to decide as to the adequacy of the CR holder, et cetera, and that maybe they would like to have a joint meeting so that you could discuss both those issues at the same time. Number one, would you consider doing that? And number two, is there a reason why you would think that Fish and Wildlife would not be a good holder?
Well, not having reviewed your proposed CR, I can't really answer the second one.
I would say that we have a long and a well-established and successful relationship with Audubon, we as a town, and so that certainly counts in their favor. Other than that, I can't really comment. As to whether a joint meeting is appropriate, that would be a decision both boards would have to reach,
Mhm.
not just ours.
Well, I understand
You know,
that.
again, we're the lesser of the two boards, if you want to look at it that way. I always try to be guided by my sense of what the Board of Selectmen, who are an elected body unlike us, what their sense of what the town's needs and obligations are.
But the land is under the care, custody, and control of the Conservation Commission.
Well, it is. Right.
And I'd also like to request that maybe the commission members could please review the CR that I've drafted to see if you feel it's adequate.
And we could do that. Well, how to proceed?
Could you, just to interrupt for a second, could you describe what your follow-up is after a conservation restriction has been put in place with you folks, and
Mhm.
other than what's in that document?
Right, right. So
What do
when
you
you say,
typically do, or
other-
have done?
yeah, so when you mean other than what's in that document, you mean the baseline documentation report?
Yeah, other than what's in the baseline documentation.
Right. So we typically go out on a 6-month to yearly annual inspection and check to make sure that the conservation restriction is being upheld. We often go out and do inventories as well and work with the landowners to see if there's any wildlife habitat improvement that we could suggest on the property. But we don't do any habitat management on land that we don't own. Obviously, we don't take that initiative unless the landowner requests it or works closely with us.
What sort of habitat improvements would you be talking about, in
So
other situations?
for instance, on other parcels, we've created turtle nesting habitats. Obviously it depends on the particular property and the particular habitat as to what kind of things you could do. Sometimes there's field management, changes to when fields are mowed or how they're mowed, that kind of thing that can sometimes improve habitat. Sometimes we work on invasive species control. So there's a number of different things. And it depends on the specific property as to, what gets done or not.
Sure.
There are some conservation restrictions that we, monitor to make sure that there's compliance, that there's no transgressions, etc. But then we don't do anything additional beyond that.
So you do a 6-month check or a 1-year check, or
Mhm.
how long do you keep that up for?
Forever.
Um,
And we just started this more aggressive proposal for some of our older CRs. So that has not always been the case. So there are some CRs that, we've had from many years ago, particularly out in Western Mass, very large conservation restrictions, where we have, not gone out on such a regular basis, but now we've changed our protocols, and so now we have a new baseline inspection. It's not a baseline, excuse me. We have a inspection report that we do, so for monitoring. So as a matter of fact, I'm going to be going out with Dave Rimmer or someone else from Essex County Greenbelt on Friday to look at one of the CRs that we have on Essex County Greenbelt property.
To what extent is your ability to do that dependent upon funding and staffing?
I don't know that I understand your question, but
What is the source of funds that permit you to maintain enough people to do this for all your properties?
Oh, well, each, it's through the regular budget, first of all.
The state
And-
budget?
Well, Fish and Wildlife budget, which is typically funded through hunting and fishing licenses, I believe. So our personnel, it's not geared, it's not,
So your
It's not
budget,
tax related.
thank you.
so your budget is not, wholly not tax related?
Our personnel budget, to my belief, is not.
That might be supplemented by grants, the stamps that you apply for?
No, I think you're confusing our land acquisition.
Well, I'm ignorant, so I don't know what I'm,
Yeah,
what
yeah.
I'm confused.
So land acquisition is funded through a number of sources, including the open space bond bill. That's where the majority of our land acquisition funds have been from the last few years, but also through stamp money as well and through federal money. Our personnel budget, as your co-member indicated, is not, doesn't come from the regular state budget, it's self-funded.
Okay.
So, and in the Northeast District, we have very few CRs. And so it's, the ability for us to, review them on a regular basis has not become an issue.
Let me ask another question, if I may, just occurred to me. To the extent that you can you describe the differences in the approaches to CRs between yourself and Audubon with regard to terms and conditions and/or doing the kinds of things we just talked about?
I guess I cannot, because I am not familiar with Mass Audubon having a lot of CRs on properties that I'm familiar with. I don't know of any CRs that Mass Audubon owns next to our properties. I don't. Do you have any in this neck of the woods? Mass Audubon CRs? I don't know of any.
I don't know.
so.
I
I don't think
Other
they
than the
own
one
any,
that's
no.
pending?
I know of many that we own in this area.
Minister's Woodlot, Patmos Road,
So there are some.
yeah.
Well, my impression of one of the distinctions that, and it's one that troubles me, is that you folks require that hunting be mandatory, or
No.
or that there
That's
has
not
to be.
correct.
Well, that's the impression you've given me in the past.
No.
That
If we pay for a piece of property or a conservation restriction, then that typically is the case. But if it's a gift, then we are more flexible. I always encourage landowners, however, to consider having an open mind regarding hunting because of the damage to habitat, to wildlife habitat that can occur with deer overpopulation. You are probably very familiar with Crane Estate and the deer population issues over there.
I'm all in favor of more deer hunting and more beaver hunting, but that's beside the point. That's a joke.
Yeah, so the answer is it's open, and I actually asked Mass Audubon that question too, because I wanted to make sure that I wasn't going to be stepping on any toes, so to speak, and so I asked Bob Ford, how he felt about it, and if they were to have the conservation restriction, if we could still use it as not a grant match. And I asked him the specific hunting question, and he said that Mass Audubon, while they don't allow hunting on their property, which I hope they will reconsider at some point in the future because of those same management, those same habitat issues that we've already discussed. he indicated that for conservation restrictions, that they do have a more open mind regarding that issue.
Well, I think they've indicated to us somehow in the past that if we wanted hunting permitted, that they wouldn't have a problem with it, but also, if we didn't want hunting permitted, that would be okay too.
Mhm.
And my impression up until just now is that hunting was going to be mandatory. But now you're saying that
No, I had to,
if you went the state route, but, or the Commonwealth, but now you're saying that if we did not want hunting and you folks held a restriction, that would be all right with.
yeah, as I indicated, we would prefer that you keep an open mind and that you maybe don't preclude the option in the future, because you could, conservation restrictions are in perpetuity. And so if you put something in the CR that says no hunting ever, and then, heaven forbid, there's a good reason, such as Crane Estate, where, ticks are overpopulated and deer are overpopulated, and you're wiping out certain native vegetation, etc., then your hands are tied. So at the very least, you might consider, keeping all your options open for the future, and maybe, being silent on that with the CR, but having specific management regulations, because it is your property after all. It's under the care, custody, and control of Conservation Commission. So irregardless of the CR, if the CR said, was silent on the issue or allowed hunting, that would not preclude you as the property owner from saying, gee, we just decided we're not going to allow shotgun this year, or we're going to do it on a limited basis, or just archery, or whatever. You could have your own regulations on the property above and beyond what the CR says.
Or confine hunting, any hunting to a certain designated area
Sure.
within the property. Another thing that has concerned me in the past is that my sense is that Audubon would be more flexible with regard to water sourcing and terminology associated with that, with regard to the community gardens situation, than the impression I got from you in one of our earlier discussions. It sounded like the language would be tighter from your standpoint with regard to maybe one possible option, when in fact there may be multiple options available here.
No, that was again, this is a draft for your review, and if the commission as a whole wanted, to have other options to avail themselves of for water for community gardens, that would certainly, I have no problem with that. Again, this was based on many emails back and forth with Brent and some phone conversations, and so he had indicated that, this was, one of the issues. But I didn't realize that there were other sources that you might consider, and yeah, we would certainly be flexible.
I think I mentioned them. I think I mentioned 3 when you were with us the last time.
Yeah, and I don't think I said no to any of them. I think some of the commission members had some other concerns, but
You may be right. I just
Yeah.
remember having a sense after the conversation that your language would be tighter than someone else's, but
yeah.
I haven't,
I haven't seen
your...
Mass Audubon's to review, to compare, so if you have another version.
I don't know where that stands either. Anyway, I think exhaust my questions and interest in the conversation.
Any other commissioners have any comments? Where I feel that I would stand in terms of moving this matter to a conclusion is I'm not prepared to change the current vote unilaterally without the Board of Selectmen's express concurrence. I'm not in a position to demand a
joint meeting with them, but I have had the sense from their office that they would consider such a thing. That's not to say they'd do it.
Well, I would say request maybe rather than demand.
Well, correct, exactly. So I can explore that with the Board of Selectmen's office, with Deborah Egan, and see if a joint meeting would be of interest to them. In terms of today, that's really as far as I'm willing to go. I'm not prepared to change the vote, which I think it would have been, to change the vote to designate Mass Audubon, but I don't think that there is any legal impediment to changing it. I just don't feel that it's our place to do that unilaterally, by which I mean without the concurrence of the Board of Select. Anyone else have any thoughts on that?
As much as I dislike joint meetings.
Well, I do.
It sounds like that's the way to
No
go.
fun to me.
I concur with that.
Yeah.
Great.
Yeah, right. I mean, it's not that I want to spend a Monday evening doing that, but I think that's the direction. I don't feel comfortable doing it any other way. So, for your purposes, Ann, we will keep you informed as to whether such a meeting is scheduled, and if so, of course, you're welcome to attend. I don't know, they meet every Monday, but their next meeting...
I think it's the 9th, but I'm having a hard time seeing the little writing over there.
Yeah, I don't think we would get on that agenda. We would probably, I don't know if they're meeting on the 16th, are they?
No.
Are they missing any meetings this month?
Next
because of the
Monday,
holidays?
next Monday's the 9th, and then the
The
16th.
meeting on the
Must be
9th.
16th. There's a meeting on the 9th, yeah, I know that.
Right.
Is there one on the 16th?
I don't know. I was only told about the possibility of their meeting on the 9th because I believe that's where the acceptance of the 710 Haverhill Street
Right,
item will be on their agenda.
right. I just, because of the holidays, I don't know what meetings they have scheduled this month, and I don't really keep track of it. So I'll make an inquiry to Deborah Egan about that.
I would doubt that we would get on for the 9th.
No, I don't think so.
Posting times.
Well, I greatly appreciate your time, and I look forward to hopefully getting a chance to meeting with both you and the selectmen, and I really appreciate your time and your respect and listening, and I would certainly appreciate it if you could take a look at the conservation restriction, and if you have any concerns at all about whether we would be an appropriate holder, feel free to get in touch with me. Brent has all my contact information, including my cell phone.
Right.
So,
We'll let you know.
thank you very much.
Thank you.
I take it nobody needs the baseline documentation report example for now.
I don't think so. Thank you.
Thanks again.
You looked at it, right?
Yes, I did.
Right. 9:30 item, which is the purchase of land, 710 Haverhill Street. Purchase of land by the town from Mr. Breen. If I recall, that was the one where it was thought to be desirable to get that done this year. So did Judy Pickett get us a deed? It's still subject to...
No, but we have the next best thing.
What's that?
The signatory pages
The signature page.
for the commission, which if you would well, let me tell you where this stands. If I may be so bold. So on November 25th, I received the hard copy of the letter from Mr. Breen, who had sent me an email on November 20th. Said regarding 710 Haverhill Street, map
well, you forgot the map. Parcel 9, Lot A. Dear Brent, thank you for your response to my inquiry regarding the land offer at 710 Haverhill Street, period. I have decided that in the best interest of the town of Raleigh, I would like to gift my land at 710 Haverhill Street to the town of Raleigh for conservation use. I understand that the town will assume the responsibility of title research and recording of the deed. Please contact me at your earliest convenience to move forward on the land gift. So upon receipt of that letter and the authorization from the commission, I've directed, the commission voted, I think at the November 12th meeting, to consider acceptance of land and for me to seek authorization from the Board of Selectmen.
Right.
So upon that vote of the commission, I received permission to contact town council to initiate the title research, which is going on now, but has not concluded. I then appeared before the Board of Selectmen on November 25th, and the Board of Selectmen voted to approve, to authorize the commission to accept 710, the gift of 710 Haverhill Street for conservation land. And so therefore, I requested from town council to be provided with the signatory pages for both the commission and for the Board of Selectmen, with the idea that the title research hasn't been concluded just yet, but if the commission would consider to voting to sign for acceptance of the property contingent upon a clear title, or whatever the terminology is for the title research coming to an appropriate conclusion, that I could present the signatory page to you tonight, and then anticipating appearing before the Board of Selectmen on December 9th. Hopefully the title cert will be concluded by then, and therefore we'll actually have a full deed, and the Board of Selectmen will be able to sign their signatory page.
So let's do that, if you have it.
Okay? You folks need to make a motion and do it, though.
Well, sure we do.
Vote to do it before I give you the page.
I'm not sure we do, because I think if we just sign it, but,
They already voted.
yeah, I'm not sure what we'd be voting to do that we haven't already voted to do. But we can vote.
Well, that's true. That's true, technically,
Sort of
because he
sign.
uses the word acceptance, and you voted to accept, so, yeah, right, it's fine, you talking about it.
Start signing.
You'll find your right line somehow. Not exactly in the right order, but
Yeah, that's it.
put your glasses on, make sure you sign the right line.
Please use your own name.
Rather than my signature match what says here.
I'm sorry?
Better not.
No, I don't, I never signed Doug Watson. I
Yeah.
never signed my signature.
I have one signature.
Right, me too.
Used for everything except notarization and trusteeship.
agenda. So 4, permits, enforcement, and what have you.
Plus, there's another set of minutes for you to
Right.
look at too, if you want to do that. So I'm willing to go into whatever you would direct me to, whichever path you would direct me to go down.
Let's just do those minutes. I don't want to forget them.
Yeah, I've already been through them, I didn't see anything.
I didn't even.
Right, I didn't either, and so I think we can do them
I've
quickly.
got one minor thing on the
I'll just-
page 2.
Well, hold on,
Gotta find it.
please.
I'm holding.
You have an updated
Now,
version?
well, yes, again, utilizing our marvelous senior assistant, Gene Blanchard.
Quality control system?
Yes.
The human quality control system. I don't know what she found, I didn't find anything.
First page of the second.
You corrected it. Yeah. In the new version.
What happened to me on another one?
Pardon?
That's what happened to me on another one.
Are you okay? Did we catch anything?
I still
Anybody
don't.
caught?
Have anything?
Okay.
That's right. I wasn't there, but I don't find any typos or anything of the sort. So, in that case, do I have a motion to approve the minutes as amended, I guess, or no?
Presented.
As presented, as presented,
So moved.
and a second,
Second.
all in favor?
Aye.
All against, and the minutes are approved. Anything else?
No, I'm sorry. And this was a meeting day too. So first thing this morning, 7:45, I get a phone call from Anonymous. And Anonymous
Our favorite informer.
asked me if I knew of construction activity that was occurring on or about the rear of 264 Newburyport Turnpike under the responsibility of Gino, however you pronounce his last name, Travalis or something like
Oh, the auto repair?
that. Yeah.
Gino's Auto Body?
Oh,
Okay.
Yeah. Gino's Auto Body. Well, this particular parcel had, it used to be Nationwide or something like that, garage that did auto repair and inspections. I don't know. Anyway, it's behind, in the front of the property, there's a separate detached structure that has an auto sales office in it. And then behind it was this
Oh, right.
garage that
Right.
used to do inspections and auto repair and
Yes.
stuff. That building is no longer occupied, tenant moved out. A short time ago, I had gotten a phone call to evaluate a building permit request for a small like enclosed entryway airlock type thing on the front of that building, and I went out there and actually met Gino and taped off and found out that his addition was 101 feet away from the edge of bordering vegetated wetlands, and therefore he didn't need to apply to us. So I was very surprised to get a call about this property, because I thought it was pretty well established that most of the side of that lot was all within the 100-foot buffer zone. And by the way, that happens to be our open space property that it abuts.
Yeah, would be, wouldn't it?
So I went out there today,
Okay, fine.
on my way to go get lunch and whatever. I stopped there and found this guy with an excavator and a bunch of cut trees and big boulders, and gosh gee golly, a bunch of fill and rocks lined up on our boundary line, 60 feet away from the delineated, well, what would be, if it was delineated, be the edge of bordering vegetated wetlands. And so I issued a verbal cease and desist after explaining for I don't know how many times that it didn't matter that he was on his side of the property line, that it was still within the regulated buffer zone, and he needed to have a permit from us ahead of time. And, oh, by the way, there's also this thing called the Stormwater and Erosion Control Bylaw, where you have absolutely no erosion controls installed, no silt fence even in sight. They showed me where the corner stake was, and one of the pictures is looking down it, and you can see that they are not quite exactly using the string method of constructing straight walls, and the wall goes off to a fishhook curve onto the Conservation Commission's open space. So,
What is the purpose of this construction?
to expand the square off the parking lot and provide kind of a retaining wall so that the parking lot just has a gentle slope to it, so it can continue to shed water towards the wetland resource area, but be utilized for parking. You can see from the aerial photo that it had a rounded corner on it. It wasn't nice and squared off. He apparently feels that to get a new tenant in the site, he needs to be able to offer a nice square parking area at the rear there. I issued them a cease and desist with an advisory that they would probably want to check where the side property line was, because I wasn't sure that the retaining wall they were putting there was straight where they were placing the boulders. And I hinted that the commission does not react favorably to the trespass of retaining walls and fill extending upon to our open space property. Plus, I also suggested that we need to put erosion control in place, and you needed to not do any further work without applying for a permit. We did come down this afternoon and pick up the materials for an RDA.
Well, good. That was a smart thing to do. It's good.
So,
who did that, Gino?
Not Gino himself, but the person he employed, a
Contractor?
Sean Russell, yeah, but he's not a contracting firm, he's just an independent guy that does little excavator work.
Just the guy with the backhoe.
He's using one of those little Kubota, mini excavator type things.
Yeah, it's in the picture there, isn't it? Yeah.
This is the place that has the source, I don't know, the rental trailer place.
Well, that's a separate parcel.
But it's in front of it.
I believe he owns and controls that. No, it's a separate parcel by itself. It has an auto sales place in front of it. Cars for sale.
That also
The campers and the rental campers are on the adjacent
Little bit
lot.
Right,
Oh,
but
they are,
they're
okay.
closer to the highway. This building is way back.
If I had him do my car body work, which I've done a couple times in the past year and as recently within the last 2 months, does that mean I need to recuse myself from this subject?
Probably.
Pardon?
Probably.
All right.
Well,
Boy, it's not that guy
Wait a
left.
second, I didn't
no,
have
wait,
to
now hold it.
recuse
When
myself.
Zamoulas came before us, nobody recused themselves because they bought groceries at Zamoulas. Now, come on.
Don't negotiate to buy groceries.
Yeah, correct, exactly.
Is your transaction complete with the other one,
It
please?
is at the moment, but
Okay, well,
But you're
then
contemplating.
I might have to
Are
go
you
back
gonna
again.
have
if
another
I-
accident next
Yes. Both my car, my truck, and my wife's car. He did body work this year.
So anyway, I'm going to issue a notice of violation.
Okay.
And have already, directed them to submit an RDA. Now, I anticipate what the next problem will be is the fact that we aren't meeting until January 7th.
Yeah.
But then again, I have no idea and cannot tell you how quickly they will put together an
Mhm.
application.
Well, let's see. This would seem to be work that they could do that is totally, like you said. How did they manage to do something that was violating,
Well, no, what they're doing, the placement of this boulder retaining wall is all definitely within the 100-foot buffer
Is it
zone. It's not,
all of it?
no, yeah, there's,
No.
well,
No.
yeah, I would believe so, because I don't believe there was 30 feet of retaining wall put in place, and my measurement to the closest boulder towards the Newbury Turnpike side was 60 feet.
Okay.
So I still had quote-unquote 40 feet to go.
Mhm. No.
So I'm sure it's all within, and the wetlands goes, it does curve around a little bit, but I'm pretty firmly sure that all their placement of fill and all those boulders and all the cut trees were all within the 100-foot buffer zone. He wanted me to tell him if you would approve this project ahead of time. I told him I couldn't do that, but I could tell him that similar projects had been approved. But I said, there's one big thing here, there is that your retaining wall needs to be on your property with appropriate erosion control and not on the town's open space property.
Yeah. That one, unlike Mr. Geddes, we will allow you onto our property to fix what you've done. So you'll have
I'm
to
hoping
fix
there
it.
isn't too much of it that's over there.
Well, it shouldn't be too hard to fix.
So anyway, just to inform the commission, that's where that's going.
All right.
Um,
Great way to start off your Monday, or Tuesday.
I have a Boy Scout, I think I told you about the signage and stuff, so I did appear before the selectmen at the same meeting with the 710 property and another thing too, and they gave an okay for signs to be erected on the open space, so even though we don't have a finished design yet or not, but anyway, I did that. Just to let you know.
I was witnessing until, did a good job.
Always surprises me how many people watch this stuff.
So I did send out another communication, which I think I emailed the commission about the dead ewes on the Wild Pastures CR property. I sent that out, so.
Oh, yeah.
I'm surprised I haven't got any response to it, so I guess I'll find out whether it's actually being addressed when I go out and take a look at at Mr. Masano's property, which.
This little cleanup project there.
Yeah, I think I had actually given Mr. Masano until today, I think, to get things wrapped up, so I'm anticipating going out there. But I thought I'd get a phone call, but I didn't get a phone call. Of course, I guess they could be away and haven't come back yet. So then the other thing is just to distribute to the commission to let you know that I received correspondence from MACC. No surprise at all, saying there's going to be a slight increase to the assessment of dues for their organization. That they will bill us for come July, or actually the end of June, for payment in July of the next fiscal year.
If we don't have a new member by then, maybe we should reduce payment for $60.
It says up to.
Up to what?
Doesn't say they have to be 7 commission members, it says up to 7 commission members.
Yeah.
But
I guess there's one or two communities that only operate with 5 commissioners.
Well, there's at least one that operates with 6.
Well, I meant as a normal compliment. Well, anyway.
Anything else? A motion to adjourn
So moved.
in a second.
Second?
All in favor?
Aye.
All against? And the meeting is adjourned.